Governor, just so you know, we're unmuted and live streaming, so make me safe and you take that. Thank you.
Attempt the court, please. the state of New Mexico.
Please be seated. Good morning. This is S-1-SC-39107, Rawlings versus Rawlings. Can I have entries of appearance, please?
Your Honor, Jocelyn Drennan and Aaron Atkins for petitioner Evan Rawlings.
Thank you.
Good morning, Aaron Friedman, your attorney, all the correspondent, Michelle Rawlings.
Thank you. Ms. Drennan, appears you've divided your time 25 minutes and 5 minutes for rebuttal? Okay, you can take it away.
May it please the court. After the Court of Appeals opinion in Buffington versus McGordy, this court amended Rule 1503.2. This appeal arises out of two of the amendments to the rule that this court made. The hearing requirement regarding objections to a hearing officer's recommendation, and the decision requirement regarding objections to a hearing officer's recommendation. In a divided opinion, the Court of Appeals read new and impractical requirements into those amendments. The majority read in a requirement that a district court must hold a hearing with the parties whenever a party voices objections to a hearing officer's recommendation. The dissent read in a requirement that in its decision, a district court must provide a reasoned basis for its ruling on objections. The new requirements are contrary to the clear and unambiguous language that this court used in wording the hearing and decision requirements as it did. The new requirements are also contrary to the overall design of the rule, which is to enable district courts to delegate potentially time-intensive matters to a hearing officer to hear and to make recommendations on, and to allow a district court to resolve objections to a hearing officer's recommendations with economy of time and effort when circumstances permit. The Court of Appeals' new requirements derive from its reading of Buffington. I'll begin with talking about the hearing requirement. Before Buffington, Rule 1053.2 included no provision that allowed the parties to make objections to a hearing officer's recommendations to the district court. Buffington held that it is required that the parties be allowed to make objections to a hearing officer's recommendation to a court. That is fundamental to the due process concept of having an opportunity to be heard by a judicial officer. Buffington also held that a district court must hold a hearing on the objections to a hearing officer's recommendation, with the type of hearing to depend upon the nature of the objection.
So what does the word hearing mean in the rule that was in effect at the time? I'm curious about this because I think the rule has some potential inconsistency in it, because it says the court shall conduct a hearing and then includes discretionary language for the trial court, appropriate and sufficient to resolve the objections. But if it's purely ruling on the paper, is that a hearing?
Yes, Your Honor.
And what supports that?
Well, I would first look at the language of the rule. With reading the provision as a whole, the hearing provision as this court amended it. If a party files timely specific objections to recommendations, the court shall conduct a hearing appropriate and sufficient to resolve the objection. The hearing shall consist of a review of the record unless the Court of Appeals determines that additional evidence will aid in the resolution of the objections. And I think what's at the root of what we contend is the error in the majority's analysis is that the majority failed to recognize that due process can be afforded without the parties appearing before the court. Due process is flexible. It does not always require a hearing or an appearance before the judge. A party may be adequately heard by a court based upon written submissions and the district court's.
It's an awkward use of hearing. I mean, we know how to say review the record. We know how to say review the objections. I don't necessarily disagree with you, although the use of the term hearing is awkward in the old reading of the rule.
Well, I think a hearing can mean to be heard by a court, and that can occur in writing. If you look at a
Counsel,
U.S.
if you-
Supreme Court case, it's
Counsel, excuse me.
FCC versus WJR.
Excuse me, counsel.
Yes, Your Honor.
Prior to hearing, though, there's an active verb, and that's conduct. That tells me that the court is supposed to actively do something. And I agree with Justice Thompson. The court knows how to say review. It has an action that's required.
Well, I think that the court a party has this opportunity to voice its position on an issue in writing, and then a court has to obviously consider the objection and then review the record and make an independent determination based on what is before it. I mean, I think that the court drafted or defined the term hearing as it did in the hearing provision intentionally to allow district courts to resolve objections with economy of time and effort. Here, it's important to remember that there was a hearing before the district court where both of the parties were able to fully present all of their arguments and all of the evidence that they wished to put in the record. And here the district court, based upon its review of the record and the objections and the recommendations, determined that it did not need to hear additional evidence in order to be able to resolve mother's objection.
Did the parties request the opportunity to present additional evidence? Or did they just file objections?
Mother filed objections to which she attached evidence, not all of which was introduced before the hearing officer, and mother was seeking an evidentiary hearing before the district court.
And another question, Ms. Drennan, is this language of conducting a hearing found in other rules of civil procedure? I ask that because does this have consequences in other arenas in the civil world where our determination of what a hearing is would have broader consequences?
Your Honor, I did not specifically do that research. I know that the Court of Appeals cited to a case in which a statutory provision had similar language. The provision has since been amended.
And the provision was amended here, wasn't it? Under the current rule?
Excuse me?
If this case were brought today, is the language any clearer in that regard?
Well, I think the court adopted amendments after this case was decided in which it replaced the word hearing with review. I think that the tendency is to associate a hearing with a court appearance.
Is that significant to our analysis?
No, I don't think so, because I think the way that the hearing provision was previously written, it was clear. If you read it as a whole, the court says a district court will not have a hearing with the parties unless the court determines that it needs additional evidence to rule on a party's objections.
Let me ask it this way. If we were to remand it, what rule would apply?
I'm sorry, Your Honor, I
If
didn't
we
hear.
were to remand, send back to the district court, is it the old rule or the new rule?
Well, the amended version of the rule states that it applies to cases pending. As of November 22, here the court decided the language under the former rule. If the court remanded with instructions to reconsider, then I think the court would have to reconsider under the language of the new rule.
So it's pending.
Excuse me.
It's pending. This matter's pending. correct?
Yes,
So it apply under the new rule.
yes.
Do we apply the new rule to our analysis on this, in this appeal, since the case is pending?
Well, I think that the district court acted under the former rule, so the case should be decided under the former rule.
Counsel, where in the original final decree does it indicate that the judge did anything more than sign off on it? When I look at the original decree, in fact, paragraph 14, she left a blank, which would indicate she didn't see it or wasn't aware of it, because it was a significant blank. It was when our child support was to begin. That was corrected in the amended. I don't see anything in the original decree that indicates she did anything more than sign it.
Well, Your Honor, I think the judge signed a proposed form of order, and an order that she realized in hindsight did not reflect everything she had done. If you listen to the hearing of the hearing that was held on October 1st, 2018, the judge was emphatic that she had reviewed the recommendations, the objections, the entire record, in ruling on mother's objections, that she had made an independent determination, that she thought the hearing officer's recommendations were supported by the record, and that mother's objections merely amounted to her disagreement with aspects of the hearing officer's recommendation. So I
Had
think,
an appeal been taken at that point?
yes, Your Honor.
Okay, did she have jurisdiction to do that?
Even if she did not have jurisdiction, technically, nothing would be gained by remanding the case for her to re-enter an order that the court already knows.
Fair enough, except it's a significant point not to have jurisdiction and enter an order. I mean, we would be blowing past that, right?
This court
We would
has
have
made,
to, let me ask it directly, we would have to ignore the fact that she lacked jurisdiction once that notice of appeal was taken.
well, this
right.
court has made, I don't think it's ignoring it, but this court has made an exception in the past with regard to the case I cited, State versus Herbstman. Nothing would be gained by sending this back. It would just prolong the proceedings. The father petitioned for divorce in 2016 and is now March of 2023.
The case upon which you rely, are you asserting this was a clerical mistake that she was correcting? I mean,
She's
it could
correct.
be this current job, but I think we do take fairly seriously the fact the lack of jurisdiction of the district court and other matters in which a notice of appeal is taken.
The judge, in terms of amending the rule, well, it's the court was entering an order nunc-pro-tunc to reflect what she had actually done. It was not to supply some omission on the part of the court. It was just something through oversight that she failed to
So
include.
is it more to clarify a ruling or provide context as opposed to an entirely new ruling or a reconsideration?
Correct. She was just documenting the steps that she had, if I'm hearing you correctly, I'm sorry, with the mask, it's
I'm sorry,
challenging.
and my voice isn't.
She was simply corrected the decree to incorporate the steps that she had followed to show her compliance with the rule in arriving at the determinations that she did regarding mother's objections.
Do you agree the first order did not comport with Fluffington as far as a reasoned basis?
I'm sorry, yeah, okay.
Do you agree or disagree that the first order entered did not comport with Fluffington with regard to reasoned basis?
Well, Buffington suggested that a court should make findings and conclusions with regard to its determination of objections. When this court amended the rule, it only required a district court to make findings and conclusions if the court heard additional evidence. And when this court amended the rule, it set forth a series of steps that a court must follow in arriving at a decision on objections. It has to review the recommendations, the objections, the entire record, decide whether or not it needs more evidence, has to make independent determinations regarding the objections. It has to decide whether or not it's going to adopt the hearing officer's recommendations, modify, reject, accept, send back with requests. So I think the steps that this court laid out for a district court to follow add up to there being a reasoned basis for a decision. Was that documented in the original decree? No, but the judge subsequently realized her mistake and she corrected the record to reflect that she had complied with the rule. Does the court have any additional questions at this time? Or
I was just assuming we agree with you and were to reverse the Court of Appeals, would we remand directly to the district court, or were there additional issues not addressed by the Court of Appeals that were preserved and raised? And I guess I don't recall, that's why I'm asking, but were there any other challenges to the district court, or was it just the violation of the rule?
Well, I think that Mother raised the jurisdictional issue, which the Court of Appeals did not reach. And then Mother also raised a constitutional due process issue, which the Court of Appeals did not believe it needed to reach because of its reading of the rule.
But there was actually nothing challenging the evidence supporting the decision or anything of that nature, if I recall.
There was no argument that Mother was unfairly prevented from presenting evidence or anything like that.
Thank you.
As you read Buffington, what was its purpose?
I'm sorry?
I'm sorry. As you read Buffington, what was the purpose of that opinion?
Well, I think one of the principal purposes was to provide the parties with an opportunity to make objections to a hearing officer's recommendations to a court, because previously the rule did not include any provision allowing that. And then also to afford an opportunity for a party to be heard by a court, because that's fundamental to due process, the opportunity to be heard by a court on one's position.
Thank you.
I think circling back to the majority's position, I think that the majority did not think about the problematical practical consequences of its ruling. It will drive up, and the dissent brings these out nicely. It will drive up litigation costs. It may cause the unnecessary expenditure of resources, and it may cause delays in proceedings because a district court may not be able to schedule a hearing on objections for weeks or sometimes even months. And that can matter when there's a time-sensitive issue like who gets custody of small children. With regard to the dissent's position about a district court needing to set forth a reasoned basis for its decision, again, I've conveyed the idea that I think the court accomplishes that, or through the steps it makes a district court take in arriving at its decision on objections. And I think that the dissent is also ignoring the problematical practical consequences of requiring a district court to set forth an explanation. And it's not clear exactly what the dissent has in mind. Is it findings and conclusions? Is it a paragraph explaining why the judge agreed or did not agree with a mother's or a party's objections? Again, that can really bog down the court in terms of time if it has to set out a detailed basis, and it's not required under the rule of the language. The language of the rule is this court amended the rule. I think when the rule is read correctly, the district court did all that it was required to arrive at its decision on mother's objections. It reviewed the recommendations. It reviewed the objections. It conducted a whole record review. It determined it did not need additional evidence to resolve those objections. It performed an independent determination regarding the objections. It determined that a hearing officer's findings and conclusions and recommendations were supported by the record. It determined that mother's objections, in essence, amounted to her disagreement with the hearing officer's recommendations. The court issued a final amended decree in which it adopted the hearing officer's recommendations. It distilled the hearing officer's findings and conclusions into determinations on the merits, and it otherwise documented its compliance with the rule.
Let me ask on that. And I too question that phrase by the dissent. Do you think the dissent added additional requirements on reasoned basis that did not exist in Buffington?
I'm sorry, Your Honor, I didn't catch all that.
Did the dissent in this case add additional requirements on reasoned basis that did not exist in Buffington? Did they add more than what was required both of the rule and in Buffington?
Well, in Buffington, the Court of Appeals alluded to Mora versus Martinez, which talks about findings and conclusions as something that ensures a court exercises care in its consideration of the issues and provides a basis for its decision. When this court amended the rule, it only required a district court to make findings and conclusions when it hears additional evidence. So I think the dissent has, in effect, added a new requirement, which even, and it's just not clear what the dissent has in mind. So I think it may raise questions in lower courts' minds, even though it's a dissent, about what it is that courts need to include in a final order ruling on objections. Does the court have any additional questions for me at this time? No? Okay.
Counsel, I'm interested in your point that we should consider judicial economy. And the reason for that is that the district court's job is to do exactly what Buffington says. It's to make decisions. If this case would be reversed, does that not send a message to district courts that they don't have to perform that core function that Buffington talks about? Because what we have here is a situation in domestic relation cases. I have 3 districts in this state that have judges that are dedicated to nothing more than domestic relations. With respect to other judges, why would a fight over discovery take priority over the custody of children, the best interest of children? Seems like judicial economy should not be a consideration at all.
Well, I think, I don't think that in using the term judicial economy that I'm suggesting in reviewing objections, a court would cut short its time. But I think if you have, let's say, a smaller judicial district in which a district court judge is hearing both discovery fights and domestic matters, the purpose of domestic relations hearing officers is to help the district court with some of the more time-consuming tasks, while nonetheless leaving a district court with discretion to hold an evidentiary hearing with the parties if the court decides that what was developed below is insufficient to enable the court to resolve the objection. But I think you can see in how things could, a district court could very much get bogged down dealing with objections. I mean, either or both parties can object to recommendations if the district court had to hold a hearing. Everyone knows that hearings take a fair amount of time to prepare for, and if the court can resolve the objections without the parties appearing before the court, that achieves judicial economy to free the district court up to attend to other matters on its docket. But I think,
And in fact, this court has already said that much with its new rule. So there's not this slippery slope type of outcome in this case.
yes, because
We've already changed the rule.
that's correct. And also, I just think that a hearing can potentially prolong the proceedings. Let's say, for example, even if it was a non-evidentiary hearing, if a party said you have to do findings and conclusions. I mean, that just prolongs the proceedings when an issue can simply be resolved based on the record and the written submissions. But again, there is room for a district court, if it decides it needs more evidence to resolve objections, to hold a hearing with the parties to gather all the evidence that it needs.
Is there anything at all? Is there anything at all in what happened before Judge Schneider to suggest that she did not exercise her independent judicial judgment in ruling on the objections to the hearing officer's report?
No, Your Honor. She was emphatic about having done her job in terms of considering mother's objections and following the requirements of the rule when she considered the objections.
Ms. Reed.
May it please the court. There are basically two tasks for the court here. The first task is to decide whether the district court complied with the rule that was in effect in 2018. And if the court concludes that it did not, then the second task is to decide what to do now in terms of remand, given the fact that the rule has been amended. What happens on remand? And I don't want to belabor the argument about what it means to conduct a hearing, but I have 2 points. The very fact that the court did away with the phrase "shall conduct a hearing" shows that in the 2006 amendment, the court intended to give the term hearing its usual ordinary meaning. And in fact, and this is my second point, if one looks at the compiler's amendment notes to the 2022 amendment, those notes say that the court removed the provision that required the district judge to hold a hearing. So as to Judge Matthews' point about the verb conduct or hold, it's obvious what the 2006 amendment meant.
Ms. Friedman, I struggle with that because of the second sentence in that subsection B. The hearing shall consist of review of the record unless the court determines that additional evidence will aid in the resolution of the objection. As a trial court judge, if I was reviewing the record, I didn't sit in the courtroom with the party staring at me as I reviewed the record. So to me, there's an equal argument that this court changed the rule because the prior court had adopted a rule that didn't make any sense. I mean, I don't think we can read too much from it because of the contradictory language in H1B. So how do I reconcile the hearing shall consist of a review of the record unless in the context of hearing in the sentence above?
I agree that it's been artfully worded, the 2006 version of the
That
rule.
rule.
I would say, first of all, as the Court of Appeals pointed out, this is slip opinion paragraph 19. If Mr. Rawlings' interpretation is correct, then the district court could never hear argument on the objections without taking evidence. So it just goes back to the wording.
But the first sentence of B does say, it says shall conduct a hearing, but then that's not the end of the sentence. It says appropriate and sufficient to resolve the objections. So if you're saying your objection is, but all the evidence was this, and the hearing officer ignored what all the evidence was, why would an evidentiary hearing be necessary in that situation, particularly in view of the language of the first sentence, how it ends? It says appropriate and sufficient. So a hearing can include, the word hearing does not exclude an on the record review. And I think, putting the two sentences together, I think the way the use notes read was that there's a presumption of an on the record review, but somebody may say, Judge, this has happened in the interim, or the hearing officer did not allow us to put in evidence of such and so that I think is important for you to consider. Then you request an evidentiary hearing, or on the other hand, you may be wanting to have oral argument or, just argument to resolve. And if the judge in discretion determines that it's necessary and appropriate to resolve it, then the judge can schedule a hearing. If the judge determines it is not, then there's no hearing as in the common, in the ordinary sense.
Complete agreement. And I think that the 2022 amendment keeps that feature of the rule, that the judge's discretion to do what is needed under the circumstances, given the specificity of the objections. Before I forget, I wanted to point out that Chief Justice Bacon asked if this language appears anywhere else, and the answer is yes in the children's court rules. I believe it's 10-163, the exact same shall conduct a hearing record, the exact same language that was in 53.2, the 2006
So
amendment.
anything coming out of a hearing officer.
If timely specific objections are filed, the court shall conduct a hearing, et cetera. Children's Court Rule 10-163, the same language survives as far as I know.
And it also appears in the special master rule.
But the language in the special master rule is different, I believe. I believe that 10-163 is the identical language that was in
Okay.
53.2 in the 2006 amendment. Whatever that language in the 2006 amendment means, if the court, or the meaning of that aside, if the court concludes that the district court committed reversible error, it is eminently reasonable here to affirm the result of the Court of Appeals in spite of the new rule, in spite of the 2022 amendment. Both the majority and the dissent agree on the result. Reversal and remand is necessary. I want to go back to one of Justice V. Hill's points that it is very hard to get a...
Why? If we conclude that the court, I need you to explain why, because if we conclude that the district court was right, what are we remanding for and to whom?
Oh, I'm sorry, that was not clear. If the court concludes that the district court committed reversible error by not following the rule that was in effect in 2018, even though the rule has changed and shall conduct the hearing is gone, it is reasonable, the court should affirm the result of the Court of Appeals, which is to say, this needs to be reversed, this needs to be remanded. Justice V. Hill asked if there's anything that the district court said that would indicate it did not comply with the 2018 version of the rule. And it's very hard to get around the fact that the district court said on the record, basically, that there was nothing to resolve. And I quote, "I made a determination that a hearing was not necessary for me to resolve anything. I am not required to conduct a hearing unless I feel there is something to be resolved." I didn't feel that.
She's saying these objections don't make any sense. I don't need a hearing on this. Out of 40 objections, I can see a district court saying 10, 20, 30, 40 of them do not require my intellectual thought to resolve. I think that's what she's saying, because the reverse of your argument is, it's just a no. I don't know why we have hearing officers, because all you do is file objections on everything. I filed objections on everything. Now, district court, I get a second hearing. It's like magistrate in district court.
The new rule, the amended rule, tells us when a general denial is permitted, and it's permitted when the judge finds that the objections are not specifically stated. And here we have a general denial. This, obviously, that rule was not in effect at that time, but we have a general denial, yet we have specific objections. Now, on your question about whether it's onerous or it's a burden on the district court, I would say that this all leads back to, all roads lead to Buffington. The rule amendment aside, it's about what does Buffington mean and what is the intent? As Justice V. Hill said, what's the purpose of Buffington? Buffington broke new ground. As my colleague pointed out, before Buffington, there was no opportunity to object, and now it's required. And it's clear from the facts in Buffington that the Court of Appeals opinion was born of some real unfairness in the process. And there is a similar unfairness here. According to Buffington, the record must demonstrate that the district court considered the objections and established the basis for the court's decision. And at that point,
But she did do that.
Yeah.
The court reviewed the respondent's objections, paragraph 7. Paragraph 8, the court independently reviewed the record in this matter. Paragraph 9, the court made an independent determination. She expressed, I applied, and this is what I think, Buffington, and we can have the debate, I think the author's in here, but I am applying some gray matter to what the hearing officer recommended. That, to me, is Buffington. Don't rubber stamp these hearing officer reports, special master reports. We don't want that. We do want you to apply discretion to Judge Matthews' point. I looked at the record and she did that. She expressed it.
and as Justice Thompson, as Your Honor pointed out, she did not have jurisdiction to do that at that point, and she already told us what she did in the final decree, and the final decree says nothing about it, and the amended final decree says nothing about fixing a clerical error.
Let me
So
ask you the same thing I asked opposing counsel then, because was she making a new ruling or reconsidering a prior ruling, or was she simply providing context and clarification of an existing order?
I would say,
Or does it even matter?
I would say, I mean, it's debatable, but I would say that she was actually making a new ruling because she came out onto the bench and she said, there is nothing for me to resolve. And the objections were specific. So then to say, I actually held a hearing and I actually did resolve them, I think that while an appellate court is exercising jurisdiction over that, the district court does not have jurisdiction to do.
What does a specific objection mean? I mean, I get generally you can say, I object to everything. That's not a specific objection. But in greater detail, what does specific objection mean?
Well,
Because you can get something that is a specific objection that's just bunk. And so we're going to say, you know, if the objection, for example, is the hearing officer hated my client, that's a specific objection. I don't think we want to order the district court to have a hearing because of some unfounded claim of bias or hatred.
I actually respectfully disagree that that's a specific objection. So the
I don't know.
The 2022 amendment gives us a clue about.
Are we going to rely on the 22 amendment for our analysis here? Or are we going to rely on the rule that existed at the time?
Well, the rule that existed at the time, all I'm saying is that even if she was held to the 2022 amendment standard of specificity in subsection G, she kind of made it. I mean, this rule didn't exist at the time, but must specifically identify the portions of the recommendations to which the party objects. She did that. A summary of the evidence. She didn't cite the transcript, but she talked about the testimony. So that's the kind of thing we're talking about. Not the hearing officer was against me. I don't think that's a specific objection, but
the witness lied. The witness perjured themselves.
That would have to come along with a reference to the finding
But
of
even
fact.
if the reference is there, if the judge can look at it on a cold record and say, there's no inconsistency here, why are we having a hearing to do that?
I agree.
But if you agree, then the specific objection isn't what triggers a hearing.
What she did here is not what you're saying. So that's my problem, is that the dissent, this is paragraph 30 of the slip opinion, no evidence that the district court considered and made an independent determination, did not adequately establish a reasoned basis for denying the objection.
Where does reasoned basis appear in the rule?
It's Buffington, and it's
But
due
where does
process.
Buffington say you have to articulate your reasoned basis, as opposed to what Justice Thompson just read, which is, I reviewed everything, the objections are denied.
What Buffington did say is that the record must demonstrate, Buffington paragraph 31, the record must demonstrate that the district court considered the objections and established the basis for the court's decision. And at the moment that Buffington said that, it cited this court's opinion in Mora against Martinez on the purpose of requiring findings and conclusions. So clearly in the Buffington court's mind, establishing the basis for the court's decision and
But the
entering
basis-
findings and
Couldn't the
conclusions.
basis be the findings and conclusion, if they reviewed the record, which they're required to do, absolutely, and they agreed with the hearing officer's decision, adopting the hearing officer's decision, if they agree with it and it's supported by the record, could meet that requirement, right? I mean, it doesn't say you have to go in and do your own new findings and your own new conclusions or your own new order. If the judge did what was required and decided that it was reasonable, couldn't they just adopt the conclusions and findings of the hearing officer?
Both versions of the rule say that the district court does have to enter findings and conclusions when required by Rule 52. And so back to my point about the basis for the court's decision, and the Buffington court talking about Mora, clearly in the Buffington court's mind, establishing the basis for the court's decision and entering findings and conclusions are related in the court's mind. There's three purposes that we can distill from Mora and Buffington, purposes of entering findings and conclusions. The first is to ensure that the decision is made by one vested with the constitutional power of a judge. The second is to promote care in considering and adjudicating facts. And the third is to ensure that there's something for an appellate court to review. So this idea that only if a district judge exercises its discretion to hold an evidentiary hearing does the court have to enter findings and conclusions is incorrect. I would argue that both versions of the rule clearly say if required by Rule 52, must enter findings and conclusions.
So assume with me, we have a case where the hearing officer gets an A+, did everything perfectly. Court looks at it and says, well, I have to enter my own findings and conclusions now, as opposed to saying I adopt the recommendation of the hearing officer because it was done so well.
The court does not have to enter its own findings and conclusions unless a party objects to that A+ version.
But
And
isn't the judge exercising its constitutional discretion, looking at it and saying, I disagree with the objection. This was perfect. Why does the judge have to enter findings and conclusions at that point, as opposed to saying, I disagree with the objections, they're not supported by the record, I'm adopting the hearing officer's conclusion?
As Judge Matthew pointed out, why is discovery more important than child custody, especially since the 2022?
I disagree that we're elevating discovery over child custody. I disagree with the premise.
Well, I guess the point, Judge Matthew's point is that, well, especially since the 2022 amendment eliminates the requirement for an in-court hearing, there should be sufficient procedural protections where child custody is concerned. This case is a painful example.
That cuts both ways. I mean, the longer these cases stay pending, the longer the children are in flux and the longer there's no finality. So I can understand the rationale behind the rule amendments and the idea that, like Chief Justice stated, if there's an A+ order, why am I as a trial court judge going to enter new findings? If I completely agree, having reviewed the record and done my job with everything that the hearing officer stated, why would I duplicate that record, have a hearing, and prolong this for this family?
That may be so, but that's not what happened here. So that may be so, but that is not what this district judge did.
What you're arguing, as I understand it, results in a rewriting of the last sentence of paragraph 2, page 2. You're saying findings of facts and conclusions of law are required regardless of whether they're required by Rule 52, because you're arguing that they're required in all instances.
No, I'm sorry, Your Honor, I'm not arguing that. If we look at Rule 52, it tells us when findings and conclusions are not required. So Rule 12 motions or Rule 56 motions or any other motion, it doesn't say anything about resolving objections to a hearing officer's recommendations. And if the objections to the hearing officer's recommendations raise issues that need to be resolved, they need to be resolved. These objections did, this judge didn't. And in terms of it being onerous, I would just say that the district judge, even when resolving the objections, can remand with instructions to the hearing officer and say, I'm having a problem with this one factual thing. Go do a hearing, get me the facts, or the district judge can make the parties do the work. Tell me the evidence that bears on this objection. Tell me the evidence that bears on your response. So it's not, if serious issues with the facts found by the hearing officer come to light in the objections, then yes, they need to be resolved. And then yes, they need to be resolved on the record.
So can I ask, assuming we agree with your position, what happens on remand? I'm wondering, clearly the new rule would apply on remand. Does that almost defeat the purpose of a remand if the new rule applies?
No, because under the unique circumstances of this case, there absolutely needs to be a hearing on remand. If the court determines that the district court erred here and is reversing and remanding, there absolutely has to be a hearing on remand in spite of the 2022 amendment that says there doesn't have to be a hearing. These children, the eldest daughter was 6 years old at the time this happened. She is now 11. The youngest was 4, and in 2 weeks she's turning 9. Those objections, those hearing officer recommendations, those objections, the response to the objections are not super germane at this point. And what is in the best interest of these children? I mean, this is just a painful example.
So you want us to write an opinion that says, district court got it wrong, you want us to remand, order that there be a hearing, although it's contrary to our existing rule?
Not a hearing to resolve objections to a hearing officer's recommendations, because as I said, they're just not relevant anymore.
You
These
want a
children,
new hearing.
the family moved on.
You want a new hearing.
Which
The
you
hearing
asked
has
for
to-
anyway.
The hearing has to determine what, given the district court's error and all the time that has elapsed and the miscarriage of justice, what is in the best interest of these children
Why
today?
can't we do that regardless?
Yeah, and mother can file a petition for,
She has.
yeah, so
Change
that's gonna happen anyway.
It's going to happen.
So again, what are we doing here?
Actually,
if that's gonna happen?
Actually, I should say, it's not necessarily going to happen because it's not clear that the district court has jurisdiction. The family doesn't live in New Mexico. The children don't live in New
But
Mexico.
if there's a fight to be had over custody of the children, there is an avenue for that continued fight, as painful as it is. That exists in the law in every state in the country.
If the court-
A custody decision is not immovable. So what would we be remanding for? And if nobody lives in New Mexico, what would we be remanding for in that instance?
Let me just say that in the interim, I mean, a district judge always has jurisdiction to modify custody while an appeal is pending. Things happen with families, appeals happen.
Yeah.
So the district court has already found that it has jurisdiction to entertain a motion to modify, for example. But what you would be doing, what the court would be doing would be not to uphold what the district court did here. I understand what the court is saying, that there are times where a court can review objections and review the record and say, it's all okay. But in this instance, given what happened and given the objections, it would be incorrect for the court to affirm or to send a message that this is okay under these circumstances. This is child custody. This is a drastic change in primary physical custody for 2 small children. And the law in New Mexico is that is not changed, or it should have been held, the status quo should have been held, that security and familiarity are important for small children. That should have been held. The miscarriage of justice.
That seems like a fight over the evidence, and that's why I asked if there were other issues on appeal not addressed. To me, I understand what you're saying. When I read it, I thought, okay, these kiddos have been with mom forever, but I just don't. To me, that's an attack on the evidence, and I don't know if that was raised on appeal as opposed to the process. And I get you have an attack to the process too, but what you're arguing now to me is really the evidence didn't support the decision, and therefore,
And
not both the district court erred and the hearing officer.
And our point in challenging the lack of procedure that happened in the district court was, one of our points was, the parties were deprived of an opportunity to request findings and conclusions on the resolution of those specific objections. That did not happen. So that has always been an issue.
Counsel, with the amendment, the 2022 amendment, aren't some of the issues that the dissent was concerned about resolved? Because the rule now inserts a Rule 74 type of review and decision. So the district court has to make a decision after affirmatively reviewing that record.
There's no question, Your Honor, that the district court on remand would have two roles. The district court would sit in a quasi-appellate capacity to review whether the hearing officer abused its discretion or that the findings were not supported by the evidence. But the district court would also play a quintessentially trial judge role. As Your Honor pointed out, that's what Buffington is about, is adjudicating facts, drawing legal conclusions. So both of those things never happened and need to happen.
On the remand, the other problem with the argument is, I understand the relief you're seeking, but there are additional problems with this Court of Appeals opinion, both in the majority and the dissent, which have been discussed here, which is they seem to be overlaying on reasoned basis more than was in even the amended order or under the new rule. I mean, the discussion at the brief in chief was, it appears even the dissent is saying, you accept these findings, these recommended findings of fact, you better insert subpart A saying, explaining why you accepted that. That's how I read both.
There has
So it's not as simple, quite frankly, as just saying, yeah, the Court of Appeals was right. Because if we left that in place, even under the new rule, you could read that to say that district court can look at the record, have a hearing, but better write down a separate reasoned basis for accepting that rule.
It's not, I'm not implying that it's simple. What I'm saying is that
Is it correct?
the result, yes, is correct.
But we can't just say the result is.
Of course not. And what I'm saying is that, again, the new rule that's in effect tells us when this general denial is permitted. This is 53.2 H2B. It tells us that the judge may issue a general denial of the objections if the judge finds that the objections are not specifically stated. So this on
But
remand.
it goes back to, what does specifically stated mean? Because it goes, I think, to a point that Justice Thompson brought up, that if you say X is not supported because of Y, and you say that everybody's going to object forever and ever on that basis, and it's going to require basically a de novo review by the district court in every single instance, because what does specific, you're saying general denial can only happen when there's a general objection.
That's what the new rule says.
I think that means in this instance, you're suggesting that at every single time there's a specific objection, there has to be a full-throated hearing. I don't think that is the point of the new rule.
I think that the district judge has absolute discretion. If the judge finds, I'm in H2B, if the judge finds that the objections are not specifically stated, it is purely in the discretion of the district court.
That's no discretion at all, because now every single lawyer is going to it would be malpractice for a lawyer not to provide specific objections so that they get a second bite at the apple, and then it goes right back to, why on earth do we have hearing officers in the first place?
Then
It's like preserving the record, and this is an area you two know very well. We were gonna see 80 objections.
Your honors may be talking about cases that are happening in the future. We are talking about what happened in the district court here. And there is.
But there's in our case, we're not going to write an opinion that's everybody ignore what we've just said, except in this case. So that idea of the specific objection really concerns me, because what we say about that here has import in the new rule as well. And again, we would end up undercutting the hearing officer process by telling lawyers, just make one specific objection and you get a full-throated evidentiary hearing in front of the district court judge.
I don't think that's certainly not what I'm arguing, and that is not the.
You just told me that if there's a specific objection, there must be a hearing.
That's not what I'm saying. I'm saying there has to be a resolution of that one specific objection, not super onerous, to resolve one specific objection. I'm not saying if there's
You
specific.
clearly haven't been a trial court judge. I mean, you're talking to
Of course,
four
of
here.
course, of course.
One hearing on one objection takes an enormous amount of time.
The whole point of the 2006 rule amendment was to codify Buffington, and while the court has clarified the procedure since then, this is still about the same constitutional principles of due process and judicial power. This family has been caught in the crossfire of a long and intense academic debate, and in some sense, there's no way to rectify the miscarriage of justice here. But to that end, the court should uphold the Court of Appeals reversal and remand for further proceedings. This thing. I have a question, but go ahead.
Well, to the chief's point, when the Rules Committee recommended this change that was ultimately adopted, they went through and did an analysis of objections that were made in the past. And just to quote from Judge Levy's letter, she says, many of those objections were because a party missed their hearing despite notice. So if I understand what you're saying, that would require a hearing.
I'm not advancing that argument.
Okay.
Those were not the objections that were filed in this case.
So assuming we disagree with you, I'm gonna ask Justice Amore a question. Is there anything for the Court of Appeals to do that it didn't do based on the original appeal?
There's a jurisdictional issue that it did not decide whether the district court had jurisdiction to amend the final decree. There's a constitutional issue, but it's so wrapped up with Buffington. The due process component of the rule is, but it did not reach a constitutional, our constitutional argument in the Court of Appeals.
Thank you, I appreciate that.
Thank you.
May it please the court. With regard to what the district court did in this case, as I've alluded to, the district court said more than my esteemed opposing counsel said. She went on to say, I reviewed the record, I considered the objections, I determined that they were supported by the evidence. So if you look at the brief in chief, you'll find a full account of what the district court said. With regard to when a court must make findings and conclusions of law, this court obviously read Buffington and amending the rule, but it amended the rule to only require findings and conclusions when Rule 52 requires. When Rule 52 requires findings and conclusions, that's in a case tried in a court without a jury or a court with an advisory jury. In other words, the judge is receiving evidence. It's only in that instance when a judge has to make findings, when a judge holds an evidentiary hearing with the parties, that a judge needs to make findings and conclusions in support of his or her determinations. I had the sensation listening to opposing counsel's argument that what Mother really was seeking was a de novo proceeding at the district court with regard to presenting additional evidence, getting the court to make findings and conclusions. And then at that point, if that's the standard, what's the point of hearing officers? I mean, hearing officers would have no role if you could start over at square one. I granted if a district court saw something seriously amiss with regard to the hearing officer's recommendations or the record, I think the district court could conduct an evidentiary hearing and adopt new findings and conclusions in support of the court's determinations. But the idea of having, unless the court thinks it needs more evidence to resolve objections, a court being required to make a whole nother set of findings and conclusions. As anyone who has worked on findings and conclusions knows, those are incredibly time consuming.
Mr. Chairman, I have two questions. One is specific to the language we've been discussing, but one is also practical. So I'd like you to tell me what specific objection means. Because I had a long debate with Ms. Friedman about that. But also, there's a suggestion now that none of the parties live in New Mexico. So if we remanded to the district court wouldn't have jurisdiction. So I want, those are the
Okay,
two things.
Okay, with regard to specific objections, I think a party has to point out the specific aspects of what the party finds objectionable or problematic about a hearing officer's findings and conclusions or recommendation. And I think, in an ideal world, for the sake of completeness, point out the aspects of the record that don't support it or that show to the contrary. And that specificity is what enables a judge to potentially resolve an objection by just looking at the existing record and the objections to determine the merits of the issue. And my opposing counsel is correct that none of the parties are currently residing in New Mexico. And I must profess, I do not know how that affects the district court's jurisdiction at the district court level. This is unorthodox, but perhaps Ms. Atkins could speak to the issue.
I think we'll sort it out for ourselves, but I appreciate the offer.
Okay. And unless the court has any additional questions.
I do have and you're probably not entirely prepared to answer this. I am bewildered a little bit by the standard of review that's in 53.2H. But Matthew raised this, when I dealt with 74, 75 appeals, I understood because they're agency decisions, they're child support hearing officer, that's statutory created. I don't understand the authority to give district courts appellate review, basically appellate review of a hearing officer in a child custody case. That doesn't make sense to me.
The only thing I can think of, I was surprised by that language myself in the new version of the rule, the one that went into effect in November 2022, unless it's to help district courts think about the potential issues that they should be looking for in a hearing officer's recommendations. But I'm not aware of the reasons why that was added to the rule. It seems to add to the work of a district court. Thank you, Your Honor. Any additional questions?
Thank you. Thank you, counsel, for your briefing. Thank you for your argument. It was a pleasure to have both of you here today. And the court deems this matter submitted as of today and will get you a resolution as soon as possible. Thank you.
Enter the court, please.